You are on bond for murder and you've now picked up an assault case. You're facing up to a year in jail and or a $4,000 fine. We are going to probable cause. You have the right to remain silent. Anything you say can be used against you. Thank you. Honor. On April 27, 2025 in Harris County, Texas, officers were dispatched to a disturbance or unknown weapon call. The complaining witness stated she is part of the nursing staff and that the defendant has been asked to leave on multiple occasions and refuses to do so. The complaining witness stated that the defendant was attempting to get her grandfather to sign over power of attorney to her, but the staff would not allow this due to the grandfather being diagnosed with dementia. The complaining witness stated that the defendant used force on the complaining witness to get her to leave the grandfather's room. The complaining witness states that the defendant put her hands on the complaining witness's face and pushed it back. The defendant was positively identified by the complaining witness and her Texas ID number. You say that there was any pain she pushed in the face. This is an assault, right? There has to be some kind of injury or pain. She did state that she felt pain in the demo. Okay, Miss Taylor, I'm going to find that there's sufficient probable cause to go Philly beat with the case. Now, you're saying there's a bond violation in this case? Yes. Good, Michael. Have you seen this? And how did you already get appointed to this case? Your Honor, I was appointed summertime very recently on this case. I received a text. I don't know what day it was, but I received it looks like it was the 29th, which was Tuesday. But how was he appointed a lawyer? I'm thinking when she was in the holdover I don't understand. Well, regardless, I guess I'm glad that you're appointed because right now she's got bond violations. She was ordered by the aware of that. Judge. I'm sorry. I wasn't aware of a BBR in this case. I actually have a BBR, another BBR today before the court. I know that. Yeah, we got you. We'll deal with that one next. But you're on bond for murder. You were ordered by the mattress to have a GPS monitor. You have violated those conditions. Unacceptable. I'm revoking your bond. She goes with you. No, Your Honor. If I may, yeah, Your Honor. She just was released because I met her in the holdover earlier this week, and she could not have been out of jail more than a day. 2 most. Would the court allow her to leave right now to get the device? No. Did she not get the device? Judge, there was a complex. That's why the DVR is submitted. Felony. So, the magistrate ordered wrong conditions, but the curfew times were not aligning with the felony conditions. So, what I mean, you still have to abide by the conditions. I mean, what did they say the conditions were? I had to move up like that. I'm not asking you to say anything, M. Taylor. The only thing I want my city protected. You're on bond for this serious case. Now you picked up an assault. I mean, you were ordered to have certain conditions. You must abide by these conditions. And Your Honor, she received conditions of bond on April 28, 2025 that ordered a GPS device with a curfew of 7 p.m. to 7 a.m. On May 1st, she had an unapproved enter at 7:52 p.m. and then left again at 8:51 until basically 9 o'clock at night. Yes, Judge. And on the felony conditions, I'm looking at them right now. Third curfew was from 12 a.m. to 6 a.m. So that's where it's conflicting. So the magistrate order from 7 p.m. to 7 a.m. and on felony her curfew was 12 a.m. to 6 a.m. I mean she still has to follow conditions, right? They may be conflicting, but you abide by the conditions, and then you come to court and you ask to do something or maybe make them align, but you just don't do whatever you want to do and think, okay, nothing's going to happen. You're on bond for 2 serious cases, Your Honor. If I may again. Sure. This is a brand new case. Could the court admonish her? Because the amount of time I understand that Michael, she's on bond for murder. She's lucky to even have a bond, and now she picks up an assault. She's ordered to have a curfew, and she's just doing whatever the hell she wants to do. In this case, Judge, that's before your court. This is a brand new case, and this is her first time having any issues while on your bond, Judge. Or would the court be willing to admonish her not to leave her home even for short periods of time? I don't know, Mike. I don't know, and my assumption is we're going to reach out to Melanie. My assumption is there's DVR for that, too. So, I don't know what I don't know, Michael. I'm gonna stew on it for a while. You want to talk about your other BVR or wait? Hold on a second. Sorry. Let me just finish with the arraignments. Give him 2 seconds and we're almost done. No problem. Good morning, Mr. Randall.SO. You're charged with assault, causing bodily injury. You're facing up to a year in jail and or $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Sir, all right. The judge on. We're doing pro here. There's no reason for you to be looking out there. We're going to do probable cause. We have to find out what happened with the case, Judge. On April 23rd, 2025, an officer disaster call and made contacted witness and the defendant. The complaint witness stated him that he saw the defendant talking to and following a witness and the witness then started to run away, and then observed the defendant to chase after the witness. The complaining witness then got in between the defendant and the complaining witness, and the defendant then struck the complaining witness with a closed fist. The complaining witness said he felt pain, and they grabbed the defendant and they proceeded to grapple until security arrived. The witness said that she did not know the defendant and that her and her friend walked past the defendant on the street. The defendant too then began to verbally harass them and started to get verbally aggressive. She asked the defendant to leave them alone and the defendant continued to refuse to do so, and that she began to walk away and to try and get away from the defendant, but got stuck at the intersection crosswalk. Then corroborated the facts that provided about getting between the two of them. Randolph, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? I'm ordering you also now not to be in possession any weapons, not to have any contact with the complaining witness, and not to go to this part of the street. Do you understand? Yet don't be a danger to my city, man. Not asking for much. I'm not in danger. I do never know these people, Your Honor. I was out. I need a public defender. I'm going to give you one, but I'm telling you now, Mr. Randolph, don't be a danger to my city. I was never a danger to I don't intend to be in danger either. All I want my streets safe. They was in danger to me and that's why I'm showing up today. I'm going to protect my streets at all costs. You understand? You protect me from these kind of people. I'm going to have you go to Victoria. Sign a reset. After that, you need a public defending office. Your judge of jail is going to give you one. I'm really scared for my life cause I just did 4 years, and I'm going through the same thing again in your courtroom when I did good and I'm going through all the facilities. They was never in a harm's way standing 100 feet away from these people or 200 feet. I was never 100 feet within there. Oh, I'm running from these people. You're going to say something that hurts your case. Just stop. Yes, say. I'm not asking you to say anything. I just want to also be safe in your community also. Don't use any dope. Don't use any alcohol. Never was. I was sober that day. I was sober as can be. No drugs, nothing. Enjoying a beautiful day for my mama's funeral. I know rules. I don't know these people. Listen, I'm going to have you sign a reset. I'm going to have you take your seat in the date. Yo, I'm not talking to you once you signed a reset. Just take a seat in the jury box. I'm going to find your lawyer, but we need you to sign conditions. Don't leave until you sign the bond conditions. Come on. You are on bond for criminal mischief that you've now picked up a new case. You now stand charged with driving while intoxicated. You're facing up to 6 months in jail and or $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay, Judge. On April 26, 2025, a law enforcement officer is on a patrol and observed motor vehicle run a red light and make a U-turn and nearly striking another vehicle in Harrisburg, Texas. Law enforcement officer observed the motor vehicle drive onto the curb of Richmond Avenue and initiated a traffic stop. Defendant passed multiple open parking lots and continued to drive. The defendant eventually pulled into a business parking and law enforcement officer contacted the defendant and observed him to be eating with fried chicken. The law enforcement officer asked why he didn't open the window and event stated he didn't have anything and continued to eat. Law officer said the defendant did not have a driver's license and was incoherent when asked to provide his name and date of birth. Law enforcement eventually identified the defendant by name and date of birth. Butefeni continues to state, I don't have anything on question about his whereabouts and center tests were conducted. The officer observed 2 out of 6 clues in the HGN, 5 out of 8 on the walk and tane and 0 to 4 on the one-leg stand. Due to the 0 to 4 on the one-leg stand due to the defendant being unable to perform the test. The law enforcement officer noted that on the walking tane, the defendant did not tane around. He stayed still for approximately 30 seconds. The law enforcer explained the one-leg stand, and after the instructions he began performing the walk. This occurrence happened again after the law enforcer tried to explain the one-leg stand another time. Law enforcement officer observed 2 unopened 6-packs of alcoholic web juice that were cold to the touch and observed an empty fuzzball and a 24-ounce can of Madela beer and an empty twisted tea alcohol. The defendant refused both breath and blood, a blood beside excuse. Whereas, I'm going to find that there's enough probable cause to go forward with your case. You said he doesn't have a license, right? There's a number here. I'm not sure if that meant that he did not have the license at the time. I have mind running it, please. Yes, Judge. Your Honor, he does have an eligible driver's license. I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I have ordered you not to pick up any new cases, not to violate conditions of bond, and you have repeatedly done that. As a result, I am now revoking your bond on the first case, and you will go to jail today. And I'm going to tell you, you violate conditions again. I'm going to make the bond so high your head will be spinning. Do you understand? You're not to consume alcohol or illegal drugs, and I will put a scram on your ankle so I know that you're not consuming. Do you understand? Yes, Your Honor, if I may. Yes, sir. On the first case, the court previously was testing Mr. Warwares 2 times a week, and he was doing pretty good on that for an extended period of time. In lieu of revoking his bond, would the court consider to going back to bi-weekly testing? No, he picked up a serious case. He has alcohol in the car. I mean, his allegedly consuming while he's driving. You know, that's I would figure that it's damn elementary that you're not to have alcohol in the car while you are driving. And there are multiple open containers cold to the touch. No, I have veto show you that we mean business. And me letting you go again when you have multiple violations, it's not going to happen. You go to jail. I don't know what we're going to do when bond's out, Michael. As far as testing now, I don't know. But I understand, Judge. I'm going to order him not to drive as well. I mean, he's got alcohol on the no. It's not gonna happen. Good morning. I'm approaching on a Victor Jesus Ra Lopez and has got a bond violation report on page 10. I see here? He's here. Judge, he's in the jury box. Speak English. Yes, he does. Come up. Answer. Yes or no? Sir, did you get your GPS device? Oh, yay. Hey, I'm revoking your B. I ordered you to get a GPS device. You didn't get it. Hey, those of you. Sorry, Maria. All right. We're going to keep you. The bond right now is good. It's 5,000 now that I already paid the house. Just raise up a 0001. 6,000, 6. It S5000 now, right? So, I'll just do 60001. Okay. 6,000. If he bonds out, yes, Judge. All right. Good morning, Mr. Arla. Sir, you're charged for driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. It looks like you're also charged with unlawful parent weapon. On that one, you're facing up to a year and a $4,000 fine. Okay. Thank you, Honor. On April 27, 2025 in Harris County, Texas, a law enforcement officer observed a vehicle traveling 50 miles per hour in a 30 miles per hour zone via radar and failed to signal at a right turn. A traffic stop was initiated and upon contact with the defendant, the law enforcement officer observed a handgun on the rear right passenger floorboard, unholstered and later confirmed to be loaded. Law enforcement officer observed glossy eyes, strong odor of alcoholic beverage, and slurred speech from the defendant. The defendant admitted to consuming 3 alcoholic beverages. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and tane, and a 2 out of 4 on the one-leg stand. The defendant consented to provide breath in Blue 8.136 and 8.141. Okay. Any practice? Yes, Your Honor. Out of a different county. Is it open? No. Your Honor, that IT was closed in 2014 with 12 months of probation. Can you run a full NCIC to see how many there are? Mr. Eiler, I'm going to find that there's sufficient probable cause to go forward the case. Also, if you can run his license, please. I'm now placing a restriction on you, Mr. Eiler. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke the bond, put you in jail. No more PR bonds. Likewise, you're ordered not to consume alcohol or legal drugs. You will be randomly tested. I'm sending notice to DPS in Austin. Every single officer in the state will know that if you're driving a vehicle and it doesn't have an interlock, you will be arrested and put into jail. Do you understand, Judge? It's just the one previous DWI license. What you say? By service. You're also not allowed to drive unless you have a valid license and liability insurance in your name as well. That is a part of your bond conditions. For now, I'm going to have to go to Victoria sign a reset. You will eventually get with Roxanne for your bond conditions, and after that you'll be free to go. It is otherwise. Great. Okay, come on, Mr. Bamanti. I know that there are 2 sides to the story. I get it. Right, that's why we have trials. But in the interim, we ask you to do several things. And when you don't, there are serious consequences. Number 1, we ask you to show up on your first case. You failed to appear just in and of itself, and we had to issue warrant for your failure. We issued bond conditions on that as well. Those conditions were also broken. You've now picked up a new case. I want you to understand something and listen, and hear me clearly. Mr. Bamanti, I want you to listen and I want you to hear me clearly, because what I am doing now is I'm putting orders of protection on both of your cases. And if you violate these, you are looking at 2 more very serious violation of a protective ordered case. That in and of itself is the capital murder of misdemeanors. Do you understand you violate conditions on that? I can have a hearing to hold you no bond. I understand 100%, sir. Oh, Your Honor. The only thing I am asking you to do is do not have contact with either of the complaining witnesses in these cases. I don't care if they're relation. I don't care if there's no relation. I don't care who they are. Do not have contact, and when I mean no contact, I mean no contact of any kind. No phone calls, text messages, social media, emails, Snapchat, whatever. Maybe smoke signals. No means no. It's not a problem. So this is now an order that identifies both as protected individuals. You cannot communicate with them. You cannot commit an assault. Commit an acting further on an offense under Section 42.072 of the Texas Field Code, which is stalking statute. You cannot threaten, harass, communicate with a third party to try to communicate with them. You cannot be in possession of a weapon or go within 200 feet of where they live or where they work. I understand, Your Honor. I got 7 kids and those are not the worst ones. I'm a good daddy. Don't talk to these 2. I understand, Your Honor. These order only applies to these 2. Don't use the other kids to try to have contact with these. If you do, we'll live together. Right. Now you don't. Right. I go to Mom's house. Best go somewhere else because they're going to inform those kids now Thatchery not supposed to be there or have contact with them. That's not a problem. All right. Except the first one, my daughter. She hasn't been here. She ran away with her husband. You know, whenever she called the car, she wasn't even at the house. I don't understand. You have contact with them. I'm not asking you much. You've already picked up 2 cases. You pick up a 3rd. I'm going to blow a gasket state. Is there anything else? Yes. There are allegations, these 2. We would ask for your analysis. Okay, you're not to use alcohol, illegal drugs. I'm going to randomly test you if I find that you're using. Likewise, I'm going to revoke these bonds and we'll put you back in. As it stands now, you are a flight risk. I'm not going to give you a PR bond. So, What'll happen now is we're going to put you back. I've got your bond set. If you have someone that post your bond, then you must abide by these conditions. My daughter, my daughter, I've given you a lawyer. You need to talk to the lawyer. You have the right to remain silent. Everything you say cause they're going to sit there and they're going to type it to use it to prove your guilt. Just don't say anything. I'm telling you what the expectation is. So if you do get out, you don't pick up a third case. I have a question. What's your question? Ask the lawyer. Okay, so we're good. Judge. You good? Okay. All right. Mr. Beaumont, you know what's expected of you from now on. That's it. Thank you. Okay. So we need him to sign conditions with Roxanne whenever she's ready. You come up here, please. Good morning, Mr. Godin. No, sir. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. So thank you, Your Honor. On April 26, 2025 in Harris County, Texas, a law enforcement officer observed a vehicle run a red light and initiated a traffic stop. The law enforcement officer made contact with the defendant, the driver, and observed bloodshot eyes, droopy eyelids, constricted pupils, unbalanced, and the defendant to be talkative and have trouble concentrating. The defendant admitted touring the red light. Standard Field Society tests were conducted. A 2 out of 6 was reported on the HGN. A 5 out of 8 on the walk and tane, and a 1 out of 4 on the one-leg stand. The defendant estimated 30 seconds passing, and what was in reality 72 seconds on the one-leg stand. The defendant admitted to smoking weed earlier. The defendant consented to breath and blew a 0. The defendant consented to drug influence evaluation, and a drug recognition expert believed the defendant to be under the influence of a central nervous system stimulant or narcotic analogic and cannabis. Thank you. And the defendant admitted he took oxycodone narcos and smoked weed. A blood warrant was obtained and executed. That should go down. I'm going to find that there's sufficient probable cause to go forward with you the case. If you have a drug or alcohol problem, now is the time for you to address it. I'm giving you the opportunity now. If I find it becomes a problem while you're on bond, I'm going to revoke your bond. I will put you in jail and I'm going to address it myself. Oxy is one of the absolute worst things that you could possibly take because you build up such a tolerance to it. You literally put your lungs to sleep if you take too much and you end up dying. I cannot tell you how many people have died from this drug. It's absolutely disgusting. And the maker has been sued repeatedly by how many different states in this country because it's such an addictive thing. Don't use. I'm telling you now, within the next week I'm going to test you because I want to make sure you're not using. Do you understand? Sir, don't use. You've got a great lawyer here. She will take care of you, but I don't care who you have here. Jesus, you use. It's not going to go well. You understand? Yes, say. License prior DWIS. The license is eligible. Okay, and not seeing any prior DWIS here. Your Honor, I'm telling you that I've had probably a handful of friends that have died from Oxy because they continue to take it, build up that punch, and put their lungs to sleep. It's disgusting. Just don't. Do you understand? I don't want you to kill yourself. Life is way too short. Yes, say. You're not allowed to drive unless you also have a valid Texas driver license and liability insurance. Do you understand? Because you have a lawyer, we will waive your appearance, but it is your responsibility to stay in touch with Miss Box, and she'll tell you if and when you have to come back to court. Be careful. Don't use. As long as you do, all is well. Thank you, M. So, it looks like you are wanted out of the state of Louisiana for larceny. It's a misdemeanor. Isn't I right? Yes, your lawyer's asking for me to set you a bond. I don't know. I need to know more about you. My primary concern, number 1, are you going to go back to Louisiana if we give you a bond? Number 2, are you going to leave a wake of destruction? Because that's what we don't want. We don't want you to be danger if you're danger. You know. Well, I know that you're going to tell me it's little bunnies jumping in the woods. Everybody does, right? But how you look on paper really tells me who you are. Your Honor. The demanding jurisdiction requested no bond. Because the demanding jurisdiction showed that she is also wanted for failure to appear for a DWI, and the FTO was issued up parish on July 21, 2022. But then she picked up this larceny within the last couple of months this year. While that was an FTA state request that there sufficient bail be set for the other future to be returned to the man jurisdiction. State requests a $10,000 bond the fact that it's a 3-year-old FTA on top case is 3 years old. No. The other ending, right? She also is wanted for a DWI out of the same parish. But this specific future case is for the larger. I'm just highlighting the reasons for the higher bail. It's because the older case was 3 years. See what I mean? That's what I'm saying. I know what you're going to tell me. But paper tells me another thing. That's a big problem. They've been on that DWI has been open for 3 years now. The only reason we have you is so. Are you okay with the bond though? Okay. With a bond, just a sufficient bond that she would turn around. Yes. Okay, yes, Judge. We wouldn't be opposed to 10,000 if you could set it at that. Okay. I want you to understand that I didn't play games. I'm not going to do this repeatedly. I can set you a bond now, but if you don't go, I'm going to revoke this bond. I will set it at 0. And this time, I'm going to hold you until Louisiana comes and gets you. And we're not going to do this again. You have one chance to make a right. We give you 2 weeks from the date of your release to go turn yourself into Louisiana. You must turn yourself in. Not I'm going to go do this. I'm going to hire a lawyer. I'm going to try to get a bond. No, just go turn. Go turn yourself in. The other thing I'm going to tell you is that Murphy's Law. What can happen will happen. Don't wait until the last day. You know what? I'm going to go turn myself in now. I don't care if you car trouble abducted be aliens. Don't matter. As soon as you get out. I would go because that's a lot of money that someone else is coning up for you to get out. Yes. Do you understand? All right. I just wanted to highlight and obviously the courts at the bond. I'm not disputing that. But just because there have been 2 other fugitives from Cattle Parish that have waived and I have 6 total from Louisiana. I imagine the transport is going to be soon. So, regarding financial capabilities on restoring the bond, one return Louisiana. So, let them know. You know what is trying to tell you basically is that because Louisiana, we have so many people in our jails from Louisiana, we have buses coming 1 to 2 times a week to shuffle in people from and to Louisiana. So if you were to waive within the next couple days, they'll probably have you back in Louisiana as opposed to someone dropping 10. You said 10,000 Marcus. So yes, as opposed to someone dropping 10,000 to get you out to go turn yourself in within the next 2 weeks. It's up to you. I'm just letting you know what it is and then you guys can decide what you want to do. Has she waived already? She's waived. That's why I can stand down if you want to talk once because you have already waived. So we give them a certain amount of time to come up. They don't come get you within that time. We release you. Once if you want to postpone, you have to withdraw that waiver and you lose all the time that you've ached toward that. But I'll explain to you and you guys tell me what you want to do. Judge. Okay. And Judge, I guess we need to have Bushnell and Doyen brought out as well for their pre-signed waivers. Just enter the present waivers. Unless you don't want them to come out to answer, then I don't care. Just have them sign it and get it. Yay. Well, they don't really need to sign. Just explain to them if they have a problem or if they don't believe you or they are giving you a hard time. Just let me know. No problem. Okay. Thank you. Good morning, Mr. Garza. Good morning. Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Thank you, Your Honor. On April 24th, 2025, in Harris County, Texas, an undercover law enforcement officer observed a vehicle conducting multiple donuts in a parking lot in close proximity to other vehicles and pedestrians. The law enforcement officer maintained visual of the vehicle until another law enforcement officer was able to conduct a traffic stop of the vehicle and detain the defendant. The defendant admitted he was the one driving the vehicle and doing donuts. Regards, I'm going to find Thather's probable cause to go forward the case. Does he have a license? It is eligible, Your Honor. Okay. I'm ordering you now as a condition of your bond not to participate in these types of activities anymore. Racing, street takeovers, donuts, reckless driving. If I find that you do, first I'm going to put you in jail. The next thing I will take your ability to drive away. Do you understand? How old are you, sir? 17.do You want a court-appointed lawyer. You need a lawyer to represent. Do you know if your family's going to hire you one, or do you want to apply? Okay. So, you don't want to apply for a court-appointed lawyer. Okay. I'm going to have you go to Victoria Sign and Reset. We'll have you take a seat in a jury box while I get your bond conditions. Don't drive maniacally. Do you understand? You are also not allowed to drive unless you have car insurance in your name as well. If I find that you do, and without it, it's not going to gowl. No, sir. Come on. All right. Good morning, Mr. Ramirez. Good morning, sir. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do the probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Thank you, Honor. On April 27, 2025 in Harris County, Texas, a law enforcement officer was dispatched to a major accident. The law enforcement officer observed a house with damaged tow garage and the front of the house. Additionally, a Harris County Constable Patrol vehicle was parked in front of another home and was damaged. The law enforcement officer observed the defendant's motor vehicle to have damage as well. The law enforcement officer observed the defendant to match the description given by dispatch and detained the defendant. The law enforcement officer met with a witness who recorded the accident and spotted the defendant as the driver. The law enforcement officer eyed the defendant by his Texas driver's license. The law enforcement officer observed a strong odor of alcoholic beverage emitting from the defendant's breath, red bloodshot eyes, and slurred speech. The defendant declined to perform standard field sobriety tests. The DIC was read and the defendant agreed to provide a sample. However, due to the defendant's age, the law enforcement officer obtained a blood warrant which was then executed. Any priv? No, Judge. License. Okay, Mr. Ramirez. I'm going to find if there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, it's not going to gowl for you. I will revoke your bond, put you in jail. Do you understand? Yes, sir. If you become a danger to my city, I'm going to do everything in my power to protect it. You're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Yes, sir. How old are you, sir? 18. Do you have the ability to hire a lawyer? Might possibly. Yes, sir, not sure. I did just apply to appointment 1. Are you working? What do you do with yourself? Yes, sir, I do work. I'm an employed full-time cashier at Bunser with Katie. But the time to the money don't I just want to know if you're working. Oh yes, sir. All right. Good job. So I'm going to appoint you a lawyer today. Thank you, sir. Don't use. I don't care where you're going, what you're doing. I don't care if Jesus asked you to break bread. Don't use that, it's not going to go well. Do you understand? Yes, sir. All right. I'm going to have you sign a reset with Victoria. We'll have you take a seat in the jury box while we have you sign conditions and find a lawyer. Okay. Thanks. All right. Good morning, Miss Reed. Good morning. You're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Thank you. On April 26, 2025, a law enforcement officer was dispatched to a Target store in reference to a shoplifter in Harris County, Texas. The law enforcement officer spoke with the complaining witness, the loss prevention officer, who stated that the defendant was observed on videotape obtaining items without payment. The defendant was observed on camera grabbing multiple items of merchandise, placing them in her backpack, and bypassing all points of sale without attempting to pay for the items. The complaining witness stopped the defendant after they had passed all points of sale, and the defendant was eyed by name and date of birth. The total value of the items taken was $119.97. No code fendants. Let me check. Mr. Reed, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to go to any target for any reason. Do you understand? Yes, sir. If I find that you do, I will revoke your bond, put you in jail. No more PR bonds, likewise. Don't pick up any new cases. Do you have the ability to hire a lawyer? Okay. We can have you felt did she F1? Yes, Jade Rio K. You're currently in school? Yes. You in school full-time? Yes. Okay. I'm going to appoint you a lawyer. M. If you want to go to Victoria, we'll have you sign a reset. After that, we'll have you sit in the jury box while we find you a lawyer, and then we'll have you sign bond conditions as well. Thanks. Morning, Miss Reyes. You were charged with driving while intoxicated. If you're facing up to 6 months in jail and a $2,000 fine, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. The right to have an attorney present. If you cannot afford one will be appointed to you. Thank you, Your Honor. On April 25, 2025, an law enforcement officer was dispatched regarding a DWI investigation in Harris County, Texas. The law enforcement officer who conducted the traffic stop stated he observed the motor vehicle traveling the wrong way down Commerce Street. The law enforcement officer stated to the investigating officer that he observed red glossy eyes. The other law enforcement officer arrived on scene and observed bloodshot glossy eyes. The defendant admitted to drinking small margaritas sample-sized drinks. The defendant stated she did not know she was traveling the wrong way down the street. Standard field sobriety tests were conducted. A 6 out of 6 was recorded in the HGN, a 2 out of 8 on the walk and turn, and a 3 out of 4 on one leg stand. The defendant consented to a roadside preliminary breath test yielding 8.12. The DIC was read and the defendant agreed to provide a breath sample for the breath test strip reading as 086 and as 088. Okay. And as I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you. If I find that you're using, I will put you in jail. You understand, man? Any priority of your eyes? No progress. License eligible. Okay. You are not allowed to drive unless you have a valid license and insurance in your name. You understand? That is also a condition of your bond. I will appoint you a lawyer today. So, what we'll have you do now is I'm going to have you head on over to Victoria, sign a reset. We'll have you take a seat in the jury box. So, I'm going to get your bond conditions, have you sign it, and we'll have you speak to the lawyer here momentarily. Okay. Please. You are Marcus Taylor. Mr. Taylor, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Thank you. On April 27, 2025 in Harris County, Texas, law enforcement officers were dispatched to a disturbance of unknown weapon call. The law enforcement officer met with the complaining witness who stated he is an employee of the State Veterans Home on the nursing staff. John Gaza. The complaining witness states that the defendant is unwelcome at the facility and has been asked to leave on multiple occasions, and the defendant has refused to do so. The complaining witness stated the defendant was attempting to have his grandfather sign power of attorney paperwork. However, nurses intervened due to the grandfather being diagnosed with dementia. The complaining witness states that the defendant used force to remove the complaining witness from the grandfather's room by pushing the complaining witness on the chest with his hands. The complaining witness stated he felt pain. The complaining witness positively eyed the defendant. Law enforcement officers detained the defendant without incident. Mr. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to go back to this location. Do you understand? If you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds. You were also ordered as a condition not to be in possession of weapons as well. We are going to reset your case to give you time to hire a lawyer. So, I will have you go to Victoria sign recess. After that, we'll have you take your seat in the jury box while we get your bond conditions. We'll have you sign, and after that, you'll be free to go. This is the judge. 1 Judges page 2 come down to those conditions. Do we want to do no returning to no? No, no. You don't need to do anything because I'm going to have her monitored, like we'll get to it in a second. Come up, you are Marvin Abelards. Yes, sir. You were charged with assault of a family member. You are facing up to a year in jail and or $4,000 fined. What we are going to do. Probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed from you. So on April 26, 2025 in Harris County, Texas, officers were dispatched to a disturbance call. Officers met with a complaining witness who stated that the defendant and him are in a dating relationship. The complaining witness stated that they had just dropped friends off and started to argue about the vehicle they were driving. The argument became physical and the defendant struck the complaining witness in the face. They closed multiple times, causing bleeding and pain. The officers observed the complaining witness to have dried blood on his face while driving. Take a closer look here. I'm going to find that there's sufficient probable cause to go forward. Anything a factor. I am ordering you now as a condition of your bond not to have any contact with complaining witness, in this case possession weapons. Mr. Ayler, I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, it's very possible they put a detainer on you and you will be stuck in custody until this case is over with, and then you get shipped to immigration. You understand? Yes, sir. No more warnings, Mr. Ayler. I'm going to protect my city at all costs. And if that means putting you in jail, I will do it in a moment's notice. The law enforcement officer observes that to be in the vehicle, but to be in the front right passenger side does not indicate that. There's a protective order that has been issued in this case yet to know. If you do something to violate this protective order, the state can and will probably file a violation of protective order against you. And that is one of the worst cases that you can look at. Are you working at this time? No, sir. Are you in school full-time? I've completed it. It's time for you to do something. You need to either work full-time or you need to be in school full-time. But doing nothing is not going to work. That is also an additional law. I will appoint you a lawyer today, but I'm going to bring you back in several weeks to see what you have done to get a full-time job. If it's nothing, do you understand? I'm going to have you sign a reset with Victoria. After that, I'm going to have you take a seat in the jury box while we create your bond conditions. Am I? Yep. Oh, you are charged with tampering with the government's record. You're facing up to a year in jail and a $4,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be punted to you soon. On April 26, 2024, a law enforcement officer was on patrol in Harris County, Texas, when he observed a motor vehicle going 82 miles per hour in a 65 miles per hour zone. Traffic stop was conducted. The law enforcement officer ran the plates and came back with no cords. The defendant stated he did not speak English. The law enforcement officer discovered a case report was made on March 27, 2025 with the same vehicle in question displaying a paper plate, but with the matching VIN number of the vehicle with no record shown on the vehicle. A Spanish speaking law enforcement officer was informed by the defendant that the defendant purchased the car 3 days ago on Facebook Marketplace and was given that paper dealer temporary tag. The defendant was questioned about the March 27th incident, to which the defendant admitted he was in possession of the vehicle during that incident as well. The defendant then admitted to operating a motor vehicle with a fake temporary tag on the vehicle. The defendant further informed the law enforcement officer that he purchased the place off Facebook Marketplace and met up with a guy 3 days prior to the incident in a Walmart parking lot to receive the fake plates. The defendant was positively identified by his citizenship card from Peru and Venezuela. I'm going to find that there are sufficient probable cause to go forward with your case. If you do not have a Texas driver license and liability insurance, you are not allowed to drive, and that is a condition of your bond. If I find that you violate these conditions, I will put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail, Immigration finds you because they sweep it hourly. They will put a detainer on you and you will be stuck like Chuck Inty until this case is over with, and then you get shipped off to immigration. Do you understand, judges? There's no driver's license information populating for this is an affidavit. This is a promise you're going to make to me that you're not going to drive. I don't care what your excuse is. I don't care what your justification is. If you drive, it's really not going to go well for you. Do you understand? We're going to have you come up here. Swear to us that you're not going to drive, that I'll have you take a seat in the jury box. Have you sign it? Yes, sir. Honor. No, Your Honor. Speak up loud enough for me to hear you. Good morning, Mr. Melcher. You're charged with driving while intoxicated. You have worked out an agreement. They're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that after today, this charge will go on your record. It's going to be there for the rest of your life. If you ever get pulled over, which is going to happen, an officer is going to look up your record. If they see that you have a Pride FBI and they roll up to our window and they smell alcohol or dope, it's probably not going to go well for you. What we're doing today from now on is a minimum of 30 days in jail. Not to mention a $6,000 supervisory fee. And if you don't pay it, every $100 you owe, you sit 1 day in jail. Yes, sir. You're giving up the right to a trial, right? Compel witnesses to test behalf. Confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, deny naturalization. You give up the right to appeal. So once you accept this agreement, there's no turning back. This is what you want, Toto. How do you plead to the office of robbing you while intoxicated, guilty or not guilty? I'm going to find you guilty. I'm going to sentence you to 3 days in jail. I'll give you credit for the 1 day that you've done. I'm going to suspend your license for 180 days, sir. Do not drive until you get a license. Good luck to you. Thank you. May we meet? Good morning. So, I'm here on Mitchell Estrada. Garrett Bach said he spoke to you yesterday on the phone. Do you have the cause number? No cause number. No. But for the other cases, it's their temporary case number. Some know but the cause number for the 011 case because that'll help us pull it up, but that'll work too. What is it? I have to spin 030431. I'm glad Gary spoke to me because he told me Blaze. I need your help real quick. Absolutely. Can I give you a cuff? Oh, she bled already. Not that I'm aware of. On what case are you looking at? Is it Mitchell Estrada? Yes. Oh, I thought she had an open DWI. She only has these 2 out of county in Lee County. She has no cases here. Okay. Can I give you a cause number? This is Michelle. Mitchell. Yes, I see that. So she has 2 out of county cases from Lee County. They're asking for a bond to be set so that she can bond out and go back to Lee County, because otherwise essentially whenever you get picked up in Harris County for a case that's out of county, Harris County holds you here for 10 days, and at that point if the out of county doesn't come get you, I give them a PR. Is there no to 'em? So that's where I guess my confusion is. She's been in custody. The hold was placed on the 29th. So, she must have been arrested here this past Tuesday. And at that point, Harris County told Lee County, hey, we got your person. So, Lee County puts the hold. I'm trying to figure out. So, wouldn't have any correct? You do not. Yay. It looks like she got taken on Class D. I mean, that's how we're doing. What do you mean? She is a bail jumping and I wanted to just run it by you guys and see. One is a bail jumping and another one is a PC's 1 to 4. You think that I've not probably in the entire time I've had this, we've only had this one other time, where it's been an issue like this, where we've had someone come and ask for a bond on an out-of-county case. So I want to make sure that I guess everybody involved is understand. It was really I got a text this morning. Is anyone in state court? I said yes I am. Did I mean I'm not? Do we have her? No, because it's a temporary case. That it's not even the thing is that we're not going to get her here until the 10th day pops up. So she's basically just sitting in a holding cell in 7200 Baker until. So what happens if we set you a bond now? You have to go Lethea know that the bond has been set. She has to make it as soon as she gets out. She has to go tain herself in counting because otherwise she's just not going to know. They want a bond set so she doesn't sit there for the next 10 days or 7-8 days. But the issue with this one, and this is largely outside of the DA's office role in the out-of-county for this. No, but I want it to be still that I know. But the issue with this one is equivalent to whenever I request the interstate compact agreement to be entered, as we largely are divorced from that proceeding and the hold is placed with the sheriff's office. So, they communicate with the demanding jurisdiction. If anything's going to happen, it's going to be with the jurisdiction and our sheriff's office. So, for the most part, there's no active matter in this court to be contested directly. And like there's nothing set a bond, but there's no case to set a bond to. That's my point, is right now there's nothing filed. There's no case number to enter in filings for. So it's like the interstate compact agreement if somebody asked. Do you hear that? So there's not, 'cause sometimes they do create a case. That does happen. I've seen it before. You've seen it before. Basically what he's saying is until the 10th day. No case number is created for me to attach a bond to. So there's nothing to be filed because there's nothing to be entered into. So it's filing documents for a case that doesn't exist for the hold itself, that there's numerous reasons a hold can be created without a case being created. And this is just one of those administrative mechanisms that happen between. There has to be a way that we can give a bond or PR bond or some way to release, right? But typically, and this is largely where I have to kind of take a step back, but if it's the demanding county that's wanting them, that's where the conversation should be because they're the ones that want. Have you reached out to Lee County yet? And I forgot to ask this, Gary, yesterday. I was just told to come by about an hour ago because it'd be the equivalent of if there's an out-of-state jurisdiction that withdraws their hold or their warrant, is I would ultimately just, I think, on a temporary casado. This give me a second, let me reach out to admin to see what more we can do in terms of if the police offer. And that's again, yeah, can you give me, let me kind of thin it out a little bit, help the lawyers that are waiting, and then because it's going to take more time for me to reach out to admin to see what I can do. Yay. Just give me, and I'm sorry that you have to wait. Do you want to go leave me your cell phone and then I can text you so you don't have to wait, and then you can always Zoom, you don't have to just sit and wait. That I was appointed on Marvin this morning on his on bond.o. So I understand that there was magistrates conditions that were done onto, but I understand that all he did was no contact, no weapons, and is not doing anything now. So hopefully we can either work full time, get into school, or do something. They saw his, doing something. They did the rip this morning. The person says that they just called the police to get things sorted out, but that they didn't want to press charges onto it. So the state had asked for no threatening, harassing it. That's what's already on there. And then I ordered no contact. But have you guys reached out to the complaining witness in this case, over the rips and done, and then the message between Sebastian and them, judge the state's willing to agree to threatening or harassing and to remove a residency restriction? Okay. Come up, point two things. I want you to understand that I've had to take in a bunch of people in jail today because they continue to violate conditions. I've already warned you. Whether you interfere with permission and what the consequences, I will modify the condition threatening or harassing, but you need to understand what is threatening or harassing. It doesn't matter what you think it is, what they perceive. If I go like this is threatening, harassing, it is find you in jail. I ask their protect order in this case. Yes, there's a protective order. So, we'll modify it. Mr. Ayla, when people have to, they become self-destructive. Point 21. You're 21 and you're doing absolutely that's not going to work. I want you to be a person and I'm going to bring you back with sure. Do you understand? All right. Okay. Nobody's thank you. Everything now, Judge. You ready to go over there with you? Give me 1 second. Let me do all I have ton of bail orders. Good morning, Miss Smith. You're charged with 2 cases. You're charged with assault of a family member. You're also charged with a garden variety assault. Both of those are Class A misdemeanor. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay. Thank you, Your Honor. On April 26, 2025 in Harris County, Texas, officers were dispatched to Ed Esteban's call. The officer interviewed the complaining witness on scene and found that the defendant observed the second complaining witness, another woman, and complaining witness 1, her boyfriend, opened the apartment door. The defendant attacked complaining witness 1, leaving visible scratch marks on her chest, shoulder, and hand. The defendant then yelled at complaining witness 2, a stranger who tried to hide in a closet when the defendant followed her and slammed the door on her toe, causing pain and her toenail to come off. The defendant then went downstairs and smashed complaining witness one's front windshield. So, we have I guess the girlfriend and then just an unknown person. Yes, Your Honor. Okay, Miss Smith, I'm going to find that there's sufficient probable cause to go forward with your cases. I'm now ordering you as a condition of your bond, not to have any contact with either of the complaining witnesses, not to be in possession any weapons. Do you understand? Yes. If I find that you violate these conditions, if I find that you pick up any new cases, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Yes. Let me see if there's a protective order that's been issued. There's a protective order that's been issued on the 27th of last month. I would get to know it. If you do something to violate the protective order, the state can and probably will file additional cases against you. Violation protective order. It's one of the worst cases you can pick up. So, know what you can and can't do. You've got a great lawyer here. Listen to him and he will take care of you. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him and he'll tell you if and when you have to come back to court. For now, we will have you go to Victoria, sign a reset. You will then take a seat in the jury box while we get your bond content. We'll have you seen it and then you'll be free to go. Thank you. So, can you file no contact, no weapons on both of the cases, please? So, you are Miss Martinez. Miss Martinez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay. Thank you. On April 26, 2025, a law enforcement officer observed a motor vehicle fail to slow down as it crossed train tracks, causing all 4 tires to come off the ground and the vehicle to go airborne. The law enforcement officer observed the motor vehicle land, lose control, and nearly crash. A traffic stop was conducted. The law enforcement officer contacted the driver and the sole occupant of the motor vehicle, who he observed to have glossy eyes and a strong odor of alcoholic beverage emitting from her breath. The defendant stated she was just at a bar called the Sugar Room. The defendant stated she had 3 alcoholic beverages. The defendant stated she had chronic back pain but was willing to perform the standard field sobriety tests. A 6 out of 6 was reported on the HGM. A 4 out of 8 on the walk and cane. A 3 out of 4 on the one-leg stand. The law enforcement officer observed a receipt in the defendant's purse, showing she had purchased 8 alcoholic beverages throughout the night. The defendant refused breath. A blood warrant was signed and executed. Okay. Any prior DWI? Oh, Your Honor. Okay. So, Your Honor, there's no traffic offense stated. He claims that the car went airborne, all dukes of hazzard. Yet there is no evidence to support that. I mean, did all wheels come off? This is a probable cause hearing, right? We're not going to get evidence at this point. I think that there's sufficient probable cause to go forward. Now, it doesn't mean you're guilty, but it's enough to go forward for now. Miss Martinez, I'm going to find that there's sufficient probable cause and I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, we will revoke your bond, put you in jail. No more PR. You understand it. Understand. Because you have a lawyer. We will waive your appearance. You don't need to waste your time coming to court. But you must stay in touch with Mr. Butler and he'll tell you when you have to come back to court. For now, we'll have you go to Victoria, sign reset. We'll have you take a seat in the jury box while you get to pretrial services, sign your documents, and then you're all right. Appreciate it. Good morning, Mr. Marshall. Good morning. Good morning, sir. You're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Thank you. On April 25, 2025 in Harris County, Texas, a law enforcement officer conducted a traffic stop on a vehicle going 58 in a 40 miles per hour zone. The law enforcement officer made contact with the defendant driver and could see in plain view a pistol and a bag of marijuana next to the defendant. The law enforcement officer detained the defendant and found another bag of marijuana in the defendant's jacket pocket. Okay, Mr. Marshall, I'm going to find that there's probable cause to go forward with your case. While this case is open, I'm warning you not to be in possession of weapons. Do you understand? If I find that you do, if you become a danger to my city, it's not going to go well for you. You just had a case dismissed, not a month and a half ago, and now you're here again. Don't be a danger to my city. Do you understand? Yes or no? Yes, say. Because you have a lawyer. We will waive your appearance, but you must stay in touch with him and he will tell you if and when you have to come back to court. Don't pick up any new cases. Does he have a, you said he was driving, right? Yes, sir. Can you run him? Does he have a license? Yes, I'll run it right now. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You must maintain car insurance. That is also a condition of your bond. If I find that you're driving without either, likewise I will arrest you, put you in jail. You understand, say? Yes, say. Judge's license is eligible. Wonderful. So, we'll have you go sign a reset now that we're going to have bond conditions created for you to sign. Once you sign it, after that, you'll be free to go. So, we'll just have you wait in the jury box. Excuse me.